Hi, good afternoon, everyone. While we wait, I'll introduce myself. I'm one of the members for the he's the one walking, and then we have two more staff here under our team. I have Melinda Salt Coates. She does the chopping, issuing the licenses and all the issues on chopping. And we have a policy analyst, uh, Justine, and we put this together in a really short period of time. I really appreciate the what you call it, everybody being here. And in the future, if you have any questions, my phone is never going off, never. It's really silent. But at the same time, you have a lot of concerns, and you don't ask for research, you don't ask for advice, you don't ask for what's going on. So we're here to serve you, but at the same time, we don't get any issues. The only time we have issues are those what's happening at your communities. But we need to plan ahead. That's one of the things what I wanted to say is we need to plan ahead. We need to strategize together. And if we do that, I think we're in a bit better position and move forward because everybody is doing everything on their own in their own territory. But what the elders have taught us, what I read, what the elders have done in the history is this. That's where we're connected on, is treaty. Your treaty, your treaty, your treaty, your treaty, your treaty. It's the same. So when it comes to territory, it impacts our territory by what the treaty is doing to us. What I mean by that is how the government is hurting our treaties. So if we could do something together, work together, call each other, and actually start working this whole process and working together. I think it would be really great to have that, and we're the department that could put that together. We could coordinate something. That's what we are as at NAN. We're a coordination. We're not taking over anything. We don't take over your processes. We don't lead your processes. All we do is bring them together and see what we could do together as a coordinated body. There's a lot of misconceptions out there that we're taking over things. It's not true. Nothing whatsoever is true. But what we want to do is we want to see what you have over here, what you're working on, and what's over here working on. But it marries together what's happening. But if we could do that, I think we would be really in a good shape. I just wanted to introduce myself really quickly and looking forward to tomorrow's discussions. We're going to ask you questions, and I hope you're going to give us those feedback. We want to hear from you, and this is what the goal of this. Plus, we want to give you information, what's happening out there, and for you to be more aware, because it's gonna. We're hoping to start the conversation for tomorrow. Igual volteava, que estive que nós comentamos.
Chief Wesley, I think you had your hand up to.
Chief Russell Wesley, Catholic. I want to share my thoughts about treaty, and in my case, Aboriginal title. The treaty sessions that we're having, is excellent work. Excellent work. We've done a lot of work over the many decades that since the signing of the treaties, and but I'm here today. Just the other day, one of my band members died. We had sent him to a detox facility in preparation for treatment. A lot of people were involved: NAPs, doctors, nurses, frontline workers, construction people, because he was homeless. We had built him a micro home, all without the resourcing framework to help him. And he died. And that's the reality today. It was a mental health and addiction crisis. It was a health crisis, health policy issue, barriers, all leading to his death. It's today. This treaty process is going to continue. It's not going to end. And we'll continue to work on it over our lifetimes. Many of us will be gone before we ever resolve the treaty issue. But the reality is, in our communities, we have crisis in education. We're underfunded to education. Elementary, secondary, post-secondary, we're right across the board. We're underfunded in education. We don't have the resourcing. Policy barriers there. Health, same thing. Every day in our nations, people are being shipped home in boxes, 1, 2, 3 at a time. Because of our health system, whether it's urban or remote. Again, a policy issue. Housing. My community, along with the young man that died the other day, I have 20 homeless people, although I've just built over 45 homes in the last 5 years. I can't meet the gap. Again, policy issues around housing. And on and on. I can go on and on the realities of today. Meanwhile, there's other concerns that we have to be concerned about in terms of indemnity clauses with all these cases that we have to launch in order to assert our jurisdiction within the treaty. I don't have that luxury, but I have to assume that responsibility for those Mishkigoman people that live in my reserve. That's why I'm here. That's the reality. I want you to just to reflect back to 1905 at the time of the signing of Treaty Number 9 and the 1930 adhesion. Ask yourself this question: what was the treaty about? It was a group of people that came to this land that needed sustenance. And they recognized the people there that were a government. They were a nation. So they had to sign treaties in order to access the resources that they need to build their hospitals, their infrastructure, their education facilities, everything they needed to be able to survive in a foreign land. Chief Scott McLeod talks about this in a social media post. He explains it very well. So in 1905, you ask yourself this question: what was it that we negotiated in the terms of the treaty? What was the economy at the time? The economy was hunting and fishing, trapping and fishing. There was a fur market that was happening. There was a demand overseas for furs. That was the economy. It was a means of subsistence for our people, hunting and fishing. So we protected it under the treaty, and subsequently it became protected under Section 35 of the Constitution. Cannot touch it. Even if you were to take the Constitution apart, you cannot touch that. So we did our jobs. After the signing of the treaty, there was terms and conditions entrenched in that treaty that spelled out the oral promises at the signing of the treaty. There was promises of education. There's promises of doctors. Fast forward 150 or so years later, we're still trying to determine and implement those clauses via court cases like this. I don't want to spend the next 150 years trying to assert my understanding of the treaty terms. It's a waste of my time because I have young men dying every day. The real issue here is the economy. The real issue here is the food and water we're going to need to put on our tables to feed our people. That is the real issue. So how are we going to do that? That's my question to you. How are we going to do that today? What do we have at our, what do we have that will allow us the leverage to force those changes? Did you know that in our First Nations, every program we have is underfunded because of one simple reason? And it all goes back to cabinet. Cabinet policy dictates funding at the program level. That's what you need to change. And the leverage you have is under your feet. The leverage you have is the land. If the nations could come to an agreement on how to use that land for their economy, that's the way forward. That's my message. Thank you.
Thank you, Russell. No, I know there are a number of questions that have been brought up, and I think tomorrow we will have that opportunity to talk about those things. And I think it is important that, and I'm keeping track of all of them, so they can fit into the right area of discussion. Because I think, Russell, Chief Wesley, when you talk about the treaty is written in a fashion that's not conducive to some of the things I think about today. And I'm sure that my forefathers did the same thing. When you look at a treaty and take it home and read it from the perspective of how it's interpreted. On our behalf as Aboriginal people, if we in fact agreed to what is written in the treaty, well, we didn't, our forefathers, when I say we, our forefathers did not agree to those terms and conditions. And do you know why? Because the treaty that the government always talks about says, I shall, or as Aboriginal people, we shall do this. Shall is a very strong word. You shall do this. But when it comes to the government, it says the government may. They may do it. To me, that's a breach of what is the non-native constitution. It's a breach of that. And I think that's one of the things that we are talking about here. We say that the government is going to do something, and Aboriginal people are going to do something. We're going to be good boys and girls. We're going to follow laws that the government passes. We're going to be good. We're going to behave ourselves. we're not going to fight amongst each other. Well, we breached all those things, and the government has breached all what it had said, what it had promised. And that breach is something that Chief Russell talks about. It's time maybe that we consider how we move forward. And I think that will not on the basis of what you call it, to try to outmaneuver the government, but on the basis of how we want to resolve the issues that are standing for a long time, 120, 149 years or so. So it is, these are very, very important questions that have been asked. This young lady over here talked about this is not how we govern ourselves. I think we all know that. It's time to move forward on the basis of what your governance was all about. If we don't do that, then we can't blame anybody but ourselves for allowing it to happen. So I wanted to thank Chief Russell for his comments. I think it strikes something in the conversation. So this time I'd like to call on Adam Fiddler. Adam Fiddler is going to talk about the misunderstanding of the treaty, caution, and compensation. Adam? You go all the time you want.
You gotta cut me off and give me a warning, eh? Miigwech Bentley, miigwech. Ego nada juiga bon jintkas. Miega gizintkan shit gimes. Name ben do dem. Ego nego zaganing doonji. Dan shiniu. Kanino go OG Cree. Kanino ge wimtus. Mi nananakum guys seguinin gipiendo mugo pangi doesn't demand treaty. Ego das miigwech tkid yo extrege one got doesn't gadek. Kstihasan gi kagwejmek nongo mike nods anek with the sandy like anek nanong treaty kayan shnim nanong. And that's to make to us at six how then go in to win the most pan ane could nanong a treaty. Sega maya make in the man sangina when go hugain taman nakumedun. That's who's got nakumed nanong gegun nanda works just the magion. Taman Larry sits is Larry here? Larry's our translating Gika Wijma. Nakamedon Segit, Nakamedon you a treaty. That's good to go doesn't got the gegun gawi jine and the mom nanunk gegun hapangaya that's gadek. Which you know gas the magion, how I am speaking said gegun gayas the maggots, eskamu bigunan. Monsieur Nakamedon Segit. So I was just explaining a little bit about the treaty, the term. I had an elder ask me, which was kind of weird about 2 weeks ago, because the elder should be telling me. She asked me, what's the word in our language for treaty? So I told her the two things that I had heard, but I've always heard just treaty.
So I told her, well, there's two things I've heard other communities, Nakamadun or Ashdamageon. Nakamadun is an agreement. Ashdamageon is a promise, so the big promise. So this morning, when Janet Armstrong was making the presentation, and then Luke spoke a little bit about some of the terminology that really hit me. Madnamageon, Madnamageon. Because I heard that term. Well, I mean, I've heard that Madnamagan is when you read the Bible, you know, the chapter and the verse that you go to, Madnamagan. It's in scripture. But I think it was 2018. There was an elders conference at the Northwester, and Alvin, it was your late dad, the late Solomon. The first time I heard him say it in this way, we were talking about land and the land, the responsibilities in managing our land, and he said, "Madnamageun, Madnamageun eyamagak." It's as if we're all responsible for a certain area. Papakandas is ganavan. We have responsibilities to that land. And that's the first time I'd heard that in that context, and I'm really glad that you pointed that out in terms of the sharing of the land, how we share the land. And I really want to learn more. So I'm looking forward to it tomorrow. I know that today has been really highly technical. I know this is an elders and knowledge keepers gathering, but it's been really technical. Even me, I'm trying to keep up. But tomorrow is going to be the chance for the elders to talk after hearing all of the discussions today. So I'll try not to make it technical. I was asked if I had a PowerPoint, and I told Victor, I don't have a PowerPoint. I don't have a presentation, but during lunchtime, I went and drafted my presentation. So this is my presentation. So I hope I get to it all. But one of the things that I want to talk about, the topic, Andrew called me sort of last minute and said, can you come and talk about the treaty? And we were trying to come up really quick about what to title the presentation. And I can't remember what we ended up, I don't have the book. What's the title of my presentation, Ben? Antagin. Okay. Misunderstanding the treaty, caution about compensation. So I'll talk about that. Thank you. But I think for me, what I want to talk about is one of our elders' teachings, one of our elders' laws, and that is Hayang Guamazin. Hayang Guamazin. In our dialects, we say it a little bit differently, but to me, that means be cautious, be careful. Hayang Guamazin. That's a fundamental teaching that has been passed on. We have to be careful. We have to be cautious. And that's what I want to talk about. We heard some of the court cases this morning. And I want to talk about being cautious. And it was clear from this morning, and Ben made the comment as well, that, you know what, when we say treaty, we all have a different understanding. We all have different opinions of what treaty is. And that's what I want to talk about, is that there's actually two different treaties. There's two different treaties. There's the treaty that our elders talked about and that they continue to pass on. The treaty, that's the treaty that our leaders fight for when they fight for our treaty rights. And we know what those treaty rights are. Those teachings have been handed down through the last several generations since the treaty was entered into. But there's another treaty, and that's the treaty that the Crown thinks is the treaty. That's this thing, these two documents in your folders. That's a different treaty than the treaty that our elders talk about. When our elders talk about treaty, they talk about what was discussed at the time of entering into treaty. The discussion that took place, the commitments that were made, the nakkamedon that was entered into. And what we heard this morning from Janet Armstrong, Dr. Armstrong, was that what the elders interpreted is totally different from what's written in here. Totally different. But what backs what the elders say is the diaries and the journals, because in those diaries and journals, they talk about what really happened. She talked about the beginning of Treaty 9, the first place where the signing took place, New Osnaburg House, Mashkiwagamang. She talked about Chief Masabe, who was presented the treaty and asked questions. And he wanted to know, are we going to be bound onto the reserve? And she talked about, she had up on the screen, I took some pictures, but I had heard this before, that the next day he came back and he had questions, are we going to be bound? And then he was told, no, that your manner of livelihood will not be interfered with. You can keep doing what you're doing on the land. And so with that, he signed the treaty. So our elders' understanding of the treaty, very simply, is we do have rights. We have treaty rights to the land. This is our land. It's a recognition of the land. We have treaty rights to hunt and fish. Well, to be honest, so does every other Canadian, every other white person. We have treaty rights to health. Well, to be honest, so does every other white person. We have treaty rights to economic development. And I want to touch on that a little bit. Economic development. Well, so does everybody else. We have a treaty right to education. So does everybody else. But these treaty rights we talk about that we grew up listening to. So as Ben said this morning, we all have a different interpretation, different understanding. I know for me, I grew up hearing about the treaty, and Chief Robert Fiddler, and I'll talk about him, who signed an adhesion to Treaty Number 5. I know other communities, it's a little bit different. Some communities didn't actually sign the treaty, and they were sort of brought in where they may have adhered to a treaty. So we all have different perspectives. But I grew up listening to our leaders, chiefs, fighting for our treaty rights. And those are the things that I think about: our land, education, health, housing even, which is a little bit farther from education and health, but economic opportunities. To me, those are our treaty rights. To basically have what every other Canadian has and takes for granted. But in 2010, in Sandy Lake, we commemorated the 100 years of the signing of the adhesion of Treaty Number 5. So Treaty Number 5 was signed by my Gobish. In Sandy Lake, we say Gobish. That means you're a great-grandchild or your great-grandparent. I know that's short form. In other communities, it's Danhu is shortened, but that comes from Danhubadan or Danhudaban. That's shortened. For us in Gobish, I think it's shortened from Danhubish. So we say Gobish. Anyway, that's not my presentation. That's not what I'm here to talk about. But anyway, my Gobish, Robert Fiddler, my great-grandfather, signed the treaty, Treaty Number 5. He signed it at Deer Lake. And he had a certain belief system, and I'll come back to that. But anyway, we commemorated the treaty signing in 2010. I was chief at the time, 16 years ago. And leading up to that, I knew in my heart what the treaty was. I knew what my treaty rights were. But I finally read the treaty leading up to it. It was the first time I read the treaty. So you've got Treaty 9, you've got Treaty 5. They're similar, but they're different. Mawach ngi matskagun nabmadzonak. Mawach ngi majendan. When I read the treaty, the English version of the treaty, I was devastated. I almost cried when I read the English text of the treaty. We talk about our treaty rights to our land. So I'm going to talk a little bit about what's written in here. It doesn't mean I agree with it, but I really hope that people can read it and understand that this is not the real treaty. The real treaty is the one that was discussed and agreed to and talked about. There's some discussion, was there actual negotiation? Well, what was actually said is the real treaty. Well, this is not the real treaty, but it's been signed. There's an X on there. If you read this, treaty number 5 and treaty number 9 are the same. Do you have treaty number 5? It's in your booklets. Treaty number 5. Go to page 4. Second paragraph. Yeah, I feel like a preacher, you know. Grab your Bible and look to it. There's no verses in here. Second paragraph. It says, the Soto and Swampy Cree tribes of Indians, and I'm going to skip. It says, do hereby cede, release, surrender, and yield up to the government of the Dominion of Canada for Her Majesty the Queen and her successors forever all their rights, titles, and privileges whatsoever to the lands, including within the following limits. So what it says there is that we ceded, released, and surrendered the land. What that means is we gave it up. And that's what the Crown thinks. This is a land surrender. But when you read it in English, that's what it says. And that's what I mean when I read that. That devastated me. That's not what our elders tell us is our treaty. We also talk about our treaty rights, that no, this is our land. Again, I'm going to read a section from this at the bottom of page 5. This is Treaty 5, and it says the same thing in Treaty 9. It says, basically, we cede the land, and then it says, saving and accepting such tracts as may from time to time be required or taken up for settlement, mining, lumbering, or other purposes. That means we can keep going out hunting, fishing, trapping, unless the Crown wants to use that land, and that's the taken up clause, for settlement, mining, lumbering, or other purposes. When I got to that section, then I really wanted to cry, because that is not what our elders understand. But that's what's written in English. So my point is, this and this is not the real treaty. The real treaty is what was discussed and talked about, the one that we know in our hearts. That's the real treaty. And that's the one that the elders will talk about tomorrow. The real treaty. But I just want to know, I want people to know what's in here, because like I said, it wasn't until after I was chief that I finally read it. When I read that. Yet that's what the Crown looks at. Now, the thing is, my Gobis, my great-grandfather, Robert Fiddler, his people had a belief system. Yuegayan Shiniwat. I was just saying to somebody, Yuegayan Shiniwat. It's not Ojikri. That's an English term that's come up. Victor was asking me. He said in the treaty at 9, it says Ojibwe and Cree. It doesn't say Ojikri. That Ojikri is just a new term, very recent. Anyway, the Anishinaabe people and the Anishinaabe and the Muskegee had a belief system. In the time of my Gobish, when he entered into treaty, I want to talk about the land, his perspective of the land. Sometimes we now hear people say, that's my land. I remember Ben Chichu years ago talking about this, that long time ago, like in the 70s, we used to say, this is our land. This is our land. Nowadays, people say, this is my land. But that was the trapline system that was created by the Ontario government that gave that caused that conflict. But the belief system from our people is that this land we were placed here by the Creator to live on, and He gave us everything to sustain life, everything. Even though it's our land, the concept is not we own the land. We do not own the land. The way the colonizer understands ownership. The land was given to us to live on. But the Western concept of land ownership is you buy property, you own the land, you build a house, you own the house. When it comes to land, that's not the concept of our people. Like, for example, if you own something, like I always say, this is my phone, Nisha, I bought it, it's mine. I can do whatever I want with it. I can give it away, I can give it to Ben, I can sell it, I can rent it, I can, whatever, this is mine. What else do I have up here? Nino and Maznegan. This is my paper. It was given to me, it's my paper. I can sell it, I can do whatever I want with it. But when it comes to the land, during my Gobish's time, he knew that he did not own the land because it belonged to not only him, but his grandchildren and his great-grandchildren and the future generations, those people that are not born yet. It's their land too. And I used to have a hard time explaining this to the colonialist mindset that, yeah, it's ours, we own it, but we don't own it because it belongs not only to us, but the future generations. It wasn't until I went to law school and I'm talking. Somebody's giving me a hint. Maybe that's Robert Fiddler telling me I'm saying too much. But it wasn't until I went to law school that I understood that there's actually a concept in the English world as well, the Western world, and that's trusts. That you can hold something in trust and you are responsible for that thing. You hold it in trust, but it's not yours. You don't own it. But there's a beneficiary, somebody who will benefit from that thing. So Robert Fiddler did not own the land. He knew that. That's part of his belief system because he held it in trust for the future generations, me and you. So it's not his to do whatever he wants. At the same time, he's a beneficiary because it was passed on from his grandfathers as well. So his belief system is that he does not own the land. So if he was explained the treaty that it's to cede, surrender, or relinquish the land, there's no way he would have done it because that goes against his belief system. So that's not what he did, but instead what he agreed to was share. The newcomers can come and we can share. And that's what was talked about this morning. So this treaty is not the real treaty. It talks about taking up land. It talks about ceding, surrendering, relinquishing land. That's not the real treaty. The real treaty, again, is what was really discussed. the oral treaty. We can say that we were tricked, we were lied to, yes, compared to this. But what we are going with is the real treaty, that we can continue doing what we've always done. Chief Wesley was talking a little bit, and there was some discussion this morning. In Treaty Number 9, it says that you can continue to do what you've always done. You can still do hunting, trapping, and fishing. Now, it was talked about already, trapping was an economy. It's a way of making money to feed and support your family. Trapping. So the treaty says you can still keep doing that. So we have the right, a treaty right, to maintain an economy, to use the land for economic benefit so that we can support ourselves and our families. That's still there. But it's up to you to decide how you want to do that. And I just wanted to talk about that. But there's a couple of things that I wanted to mention regarding being cautious. One is cows and plows. Cows and plows is a big thing out west, Manitoba, Saskatchewan, Alberta. The treaties, Treaty 4, Treaty 5, Treaty 6, have clauses in there in the written version. It says that they will provide basically cows, farming equipment, plows, and ox. There's a list of things in there. If you want to see it, it's in that Treaty 5 document that you have. It's on page, where is it? It's on page 6, sort of towards the bottom. There's a whole paragraph there of all the stuff that was committed. Basically, they call it cows and plows. It's to allow you to become a farmer so that you can become self-sufficient and you can care for yourself and establish a mechanism of supporting your family and your future. Where I come from, we don't have any farms. We don't have cows. We hunt, fish, trap. So what I've often said is, I don't know what Robert Fiddler was told, but I firmly believe if he was told that as part of the treaty, we're going to give you cows, we give you plows and ox and farming equipment, he would have said, I don't need that. I hunt and fish. I don't need cows. But I firmly believe it wasn't even talked about because that's what's written. Instead, what was talked about was planting a seed and sharing and providing the resources to live a good life. That's what was talked about, including economic development, because the people could still keep doing what they were doing. Trapping at that time was the economy. By then, Hudson Bay Company had been around for hundreds of years, several hundred years. So the treaty says that you can keep doing that. So all of a sudden, in the last several years, there's these settlements, cows and plows settlements, where First Nations from Treaty 4, 5, and 6 are taking the government to court, and the government is actually settling huge multi-million-dollar settlements because the reality is in the treaty, it says they will provide cows and plows. It's in there exactly what they'll provide, and they never did. So in lieu of that, they are now offering settlements, multi-million, hundreds of millions of dollars that the First Nations are accepting. But as part of that, you accept and you sign off that once and for all, that ends your claim to that. But the reality is what we're doing is our belief in the treaty is what the elders believed in the real treaty, not this thing. This is not the real treaty. These two. So if we start settling things that are in here and take it to court and say we demand this, which in a way represents and symbolizes the things that were talked about over here, are we then accepting this? Are we accepting this? Are we accepting that we ceded, relinquished, and gave up our land? Are we accepting that there's a taken up clause, that even in Crown land, that they can come and do mining and forestry? Are we accepting that? I have a feeling I know what the elders will say tomorrow. But yet that's what we're doing. We're opening and we're taking this and we're solidifying what's written here and disregarding our true, what I've often heard, the spirit and intent of the treaty. That's what's being done. So my position, and I know that many First Nations are doing this out west, my position is, if that's what you're going to do, is be very careful. Be cautious. Make sure it's clear in there that you're not settling once and for all, because once you settle once and for all, that's it. Future generations lose that opportunity to receive help, things like economic opportunities, and to be able to have a good future. You're giving that up. So make sure it's clear if you're going to sign anything like that, that you're not actually signing up your true beliefs of the treaty. That would be my recommendation. The other case that was mentioned this morning was the treaty annuities case. There was a little bit, we all know about the Robinson Superior Treaty, a $10 billion compensation payout. But what we have to realize is that treaty is different. In treaty number 5, it says we get $5 a year. Treaty number 9 says $4 a year. In the Robinson Superior, there was a certain amount every year that they would get. But there's an escalation clause in there. And I'm paraphrasing, I'm just going to use my own words so it's understood. Basically what it says is, but if we start making more money off of the land, we will increase the annual payment. And guess what? They've been making millions, billions, trillions of dollars, and they never increased the annual payment. And in fact, I'm surprised that it took that long for them to take that to court. So they took it, they won. There's a $10 billion settlement to compensate them for that loss. The process they're in right now is from today moving forward. How are they going to do that? So they're still negotiating that. Now, the thing is, that was in the treaty. That was actually a treaty promise. People are asking, what about us? We only get a measly $5. Can't we take it to court? Because $5 back then is not the same. But yeah, but if you look at, there's different formulas you can look at, like the buying power of $5 or the inflation. There's different amounts. It could be $162 in today's money. It could be, depending on what formula you use, maybe up to $400. But it's roughly, people will guesstimate less than $200, your treaty payment that you get every year, your annuity payment. So the question is, do you really want to take the treaty to court? Do you really want to take the treaty to court? Do you want to say, the Crown, this is what it says in the treaty? Because then what you're doing is you're justifying, you're acknowledging that this is a true, in fact, treaty, when your position has been something else based on what the elders understood. Do you want to go there? And the other fear, years ago, there was a chief that I was listening to from his community. I won't name, but I remember that elder. He's passed on. The chief said, that elder told us, don't ever take anything to the white man's court system. Because if you take it to the white man's court system, it's their rules, their laws, and they'll win every time. Don't ever take what you have to their court system, is what that elder had said. So that's the caution. So again, do you want to take that and put what you believe in to make this legitimate? The other quick example, Andrew, where's Andrew? He was right here in the back. Was just pointing out a recent case. So this is in the Treaty 4 territory. Regarding their $4 annuity, there's two First Nations that want to take to court a class action, which means they represent all the First Nations, to look at that $4 annuity and ask for an increase, just like the Robinson Huron. But they don't have that clause either, that it will increase. But they applied to the courts to put forward a class action. In the end, they were told, no, you can't put forward a class action, but you can go forward on your own. But Andrew pointed out, and I had a quick look at it. So when a judge makes their decision, there's different parts of the court order. Sometimes it's hundreds of pages. At first, they put the information, title page, and then they list the facts. The facts, nobody disputes. That's the facts of the case. Later on, they talk about what's the issue, and then they talk about their decision, why. But the first part, nobody takes issue to. That's just the facts. So in that case, in that Treaty 4 case, the judge went through the facts. And the judge said, Treaty 4 ceded vast tracts of land, some 50,000 square miles to Canada. So that's what the judge says. Nobody's questioning that. The judge says Treaty 4 relinquished, ceded 50,000 square miles. And nobody even questions that in the decision. That's accepted as fact. And the concern is that if that's accepted as fact, what about our understanding of the treaty? The elders' understanding of the treaty, what you're going to talk about tomorrow. So if you take something to their court system, like that elder in that community said, you're opening the door and you're giving them that authority. So I guess I'm here to just give some examples and to explain and what was already said, that there's two versions of the treaty. There's the paper that you have, the one that made me cry when I finally read it, and there's the real treaty, the one the elders talk about. But we have to move on from that. And the part that I want to grab onto is Treaty number 9 says you can continue. What Chief Masabe was told, your manner of livelihood will not be interfered with. You can keep doing what you were always doing. One of them is trapping, and that's an economy, using the land to provide for your family. And in modern day terms, it could be something else other than trapping. And that's some of the things we need to start looking at. I see Ben kind of looking at me. They might cut me off soon, but those are my brief comments. I think initially I had 15 minutes. They gave me a little bit more time. So we're good. I can keep going. One more little thing. I was comparing the two treaties, Treaty 5 and Treaty 9, and I didn't know this. I thought it was in Treaty 9 as well. When I first got elected to council at the turn of the century, it sounds such a long time ago, not that one, but in 2000, 26 years ago, I was a councillor. I got a check in the mail from the government of Canada, brown envelope, $300. It should be good. Yeah, $300. So I didn't know what that was. There was some reference to treaty. So I took it to the band office, and Jonas Fiddler was a band counselor there at the time. I was just a mid-20s. And I said, they got check, 300. And they explained to me that that's actually in the treaty, that in Treaty 5, it says that the treaty promise obligation is a suitable piece of clothing. And he says, that's $300 to go buy a suit. But he said in our language, what he said was, Emi nugoyin, santo manipsganein, ega jamamashkanaguzien najugmawin. Said, is to buy a suit so you don't look so scruffy looking when you go see the officials in Ottawa. I thought he was just kidding, but it's actually in Treaty 5 that you get a suitable piece. So every 3 years, I guess 4 times, I was on 12 years altogether. Every 3 years, I got $300. But my question then, this is not what I was just filling some time, Ben. You can cut me off whenever. But my question is, how do they determine $300? Like my $5 a year didn't go up. Where did $300 come from? So back then, I never wear suits, eh? So $300 might have bought me a suit. Nowadays, $300 won't even get me a nice shirt. So anyway, just thought I'd share that there's little discrepancies and differences. Anyway, Amazon, be cautious, be careful. And I really look forward to tomorrow. It's not going to be a technical discussion, but the elders are going to talk about treaty based on what you heard today. Yeah, Morris, I don't know. Ben, I should give it to you. He's got a question. Yeah.
Hello. Yeah, my name is Morris Wapus from Niskandiga. I'm considered as my status is off reserve. But anyway, couple of things before you get off the stage there. You talked about people saying my land, right? And there's another term that troubles me. I went to Lake Hill University this summer to listen to a First Nation presentation. And the word that they use is my territory. Okay. And that's nobody else's kind of thing. That's the way I took it, and it troubled me as a status Indian, you know. Before all this legislation, like in the trap lines in Indian Act and and so forth, before all that, if I woke up in BC, I would say the same thing. This is my land, and because as status for Indigenous people, we roam the country here, and that's what troubles me when somebody says, this is my territory, nobody else's, and I don't, as an individual, I don't believe that, that's just my own thinking, as an individual, I certainly respect where we're all situated, and that's one thing that I just wanted to mention how this relates to the treaty that we're talking about today, and the other thing is what is the underlying reason for the annuity? Why people got paid $8 and like Treaty 9 when the signing took place and $4 thereafter. Like, I mean, what is the real reason for that? Like, and and as you know, like I said earlier, like some people never got paid because they weren't at the treaty signing. So how does that relate to these two issues here? Thank you.
Yeah, Miguel. So regarding the second point, and then Brenda, I'm going to take over chairing your meeting here, Ben. Regarding your second point, the first year for Treaty 9, so I'm more familiar with Treaty 5. I think Janet and Mike Sherry can speak to it. I don't know if they're on, but I know that the first one was a present. One was the actual, here's the treaty, and then there's an annual amount given. So it was the very first one for the treaty, and then as part of the annual. So that's why you got two the first year, is my understanding. But Mike Sherry, I think, and I don't know, maybe even Luke can probably, Luke's got more knowledge. He could probably respond to that part. Going back to the first part about my land and our land, I think the point I was trying to make was that Ben really struck me when I heard him say years ago that people used to say our land, Mamo, all of us. Now it's my, me, personal. And we need to go back to our. It's our. But the thing is, it's not even my land. At Gaganin, where my dad was born, Noden Zaganing, says in Kade, Noden Zaganing, Windy Lake. But in English, somebody came along and called it Favorable Lake. That's where my dad was born. That's where my grandfather, my great grandfather, they were. And to me, I don't say that's my land because the land doesn't belong to me, but I belong to the land. De Bendagwazon, Mshema Wens de Bendagwazian, Yima Noden Zaganing. That's where I belong, to the Favorable Lake. I don't say Nin Shayu de Bendan. And that principle of us belonging to the land, there's a connection there, spiritual connection. And that's important. And where that flows from is that attachment, we have that connection. That's why we often are so proud to say where we're from. At the beginning, I was told when you introduce yourself, we dan ando Indian. That's part of my introduction. Who I am, but in reality, I'm Noden Zaganian. I'm from Noden Zaganig. And that's where you belong. So it's not really that it's my land, it's I belong to the land. Anyway, there was another hand up, but I think we're.
Over here, Adam.
Do you want Luke to respond to the other question, or maybe that can come up in the discussion later? Yeah, Brenda.
The question that I have is, we're getting jigin, kenanga jina kundigan Migeni Nation, Yagai Kitain, Kendan Patino, Yagani, Gishinakshkan, Waga, Kenagani, Giniganian. When you kick a Gweza, Gitam, Uchkita King, Katishikin, Kashitibenda, Gazin, Kananga Ishtigasik, Kagishtigasik, Sukuchipin, Chipopin to get magic of Gwetich. Mieshtigoch, Ganak, Gayochka, Kabe, Gogo, Sinin, got tapinochka, Gogo, Popkakan, Gago, Storchen. Ich bin die Georg, ich open it and dom the watch. Can you be the Margaret Desiog? Mishes Sam, Gok, Kishna Bayan, Pangi, Ganonto, Gochoma, Gochoma, Benamai Jog, Benamai, she said, Ganonto, Margaret, the Benji George, got the Shiki George. Miege, the Morgan George. Misschien keer te go je shows te watch again. Mi egi kitain mai. Mi go te go je nista te watch kani nista tu zino hour. Kunet ni gai chigate nek mi shishe je pekan ke sem kukin that mi a treaty and our laws. Mish magegi je mashko sem ko panaje kenan bishiki gigi kanoni gomen china nagiten mai gog ni chance nanik us nanik and ko chignanik. Sketchgashichna nagtent, but Nimigochen Magni Nashigana Kagit and Nagtent, we shoot Chisnago Kentucky. China Nagton, Chicken the Manga Gajijan, Chicken the Manga Gajina Nagton, Kagisho Biki Gong. Mrs. Mash Buksendago ki no ki nit Gajikan, the Mangashi Machik no more gob, Nick Nichans Nanak, our laws, our traditional laws. They need to be documented. I know that we are going to be talking about UNDRIP. Mishish Majnu this saying, Kendan Yano Guy Kitten judge and we know guy should be George. Kanika Gini Tibagitin go see me Josh doing Ian and the can in Ashikitagin and Nagitan Damin is just doing. Shikagitan Kubichigam. Me and it great grandchildren guy to get take Animshinin Dan Kubichigasin Doshis Agosh Neosak. Michigan gana nagten mago aje yen denentem aje o mag chi coach news chan kubchigan and paming is nagondik of mat sigi shin na kon again the sto singe gas ka got asna aje ingen ni boge gon git shipaki na gumen Mishin bishikan ji kitangani miziga babajan wege ginit hit na kon again our traditional laws gegen each keep mention man gibinin na shit chigate gibinin chas gatek the treaty. We need something to support the treaty the way that our people understand it, and that's our traditional laws. It's not documented, and I thought about that lady on the history told that we need to start documenting our history. Me share me now your caution. The best there's things that we cannot write because they were given to us by the Creator. Ni Jesus mi ega and chigatag mi shega tashigi je nanga jim shkai sam gok. Ashna gi mi ni gomen mi shega jin statago ke gonga kitenga go kitengi go no magain gishna bem. Mi shega jim shkai sam gok mi shent ke ajit gish go na na gitan mangaban mi shkai set twink wa. Wega gajit tashin jigeng minini gana gajit na na gitan mago. Man tige go ga wega nish na gok. Mi shega inen daman mi gach.
Very good, Brenda. Te dag gawin in the moment. Mayam getting me in the man. I totally agree. I could talk for another hour just to get all excited talking about this stuff, but Ben is giving me that look. So you get.
Okay. Thank you, Adam. What we'll do is we'll take a break for 15 minutes and then we'll come back and we'll have Ron Lehman. If I'm pronouncing the name properly, I don't know whether I'm not. I am or not. So we'll have him make his presentation and then we'll continue on from there. So take a break, 15 minutes.
Probably the Elfin Center.
Okay, we're ready to start for after our coffee break. I hope everybody got a coffee. Okay, if everybody could come in, we're ready to start. Okay, so we're going to get started. Ron Lehman's ready to begin his presentation. We won't have this, won't be ready yet because of the power outage we had and knocked this out. So we're going to have only one. Going to get started. Ron Lehman's ready to. So Ron, whenever you're ready. Outage we had and knocked this out. So we're going to have only one. Let's start. Lehman's ready to. So Ron, whenever you're ready.
Oh,
Outage we had and knocked this out. So we're going to have only one. Let's start. Lehman's ready to. So Ron, whenever you're ready.
okay.
Outage we had and knocked this out. So we're going to have only one. Let's start. Lehman's ready to. So Ron, whenever you're ready.
Tapos. Okay.
Outage we had and knocked this out.
No ako magantek. Nanas ko man sabi na tawawi ha ano maka which mamo pimtagok. Tapos muyok tantayan. Uya gatsi gai kaskihtaan katagohtian magaya apoy to ikihtom. Miosin ktaski wow. Ego tagakihtat na o kais mamskutsigi kais na nihiyoik. Kapapamagutsan sikason is nihiyoikasan. Good afternoon, friends and relatives. Really glad to be able to once again sit with you, although I'm not there. Unfortunately, I couldn't make it over there, but nevertheless, I'm glad to be in a meeting with you and listening to your people speaking. And I know our versions of the Nihiyoewan, the Cree language, are not so different, but I know here and there we can understand one another. But nevertheless, I'm glad to be here. and my apologies for the not being there on this morning. Got a little mixed up on the time change, and with I'm sure everybody uses this with the daylight savings time we have over here, but nevertheless, I'm here, and I'm really glad to be able to uh, make this presentation that your technical people had wanted me to do. In particular, Andrew. So I'm going to go ahead and get started. I won't take too much of your time. I was mentioning my name is Ron Lehman. I also have a Cree name, Nihiawikasun. To literally translate it, it means the one that goes all over, flies around all over. And an elder had given me that name, named after the sweetgrass. When you light the sweetgrass, it goes all over the place, makes its way to where the Creator sits, and gives our message to the Creator. And he said he gave me that name because of the work that I do, being a political supporter or activist. A technical person is more what I am, although I was on council for 12 years, way back many years ago, and I was much younger. So I'm going to go ahead and get started. I'm going to depend on your technician to help me out. This one on the screen right now is when our people first went to the United Nations back in 1977 in Geneva. And some of the people, and if I was there, I could point them out to you, but this handsome older fellow here, the one frontmost over here, his name was Philip Deere. He was a Muskogee Creek from Oklahoma. And about the middle and maybe about 3/4 to the back, that handsome young man with the braids, that's Bill Means. He's still alive today. All the Means brothers have passed on to the spirit world, but Bill is still alive, and he's on our board of directors of the International Indian Treaty Council. He's a little bit up in years, and he's doesn't have the best of health, so you can remember him in your prayers. Next screen, please. And way back in 1974, a lot of us were doing work over here in our part of Turtle Island. But in 1974, there was a meeting that was called for in a place called Standing Rock, South Dakota. And a lot of you will know about Standing Rock because of what happened there just a few years ago when our people were standing up for their rights. And there was a lot of controversy on the pipeline that they were trying to force through their territory. But back in 1974, one of my late brothers, his name was Edwin Burnstick Sr., he attended the meeting in Standing Rock. And this is where the UN Declaration started, or versions of it. And they wrote down and agreed to what's called a Declaration of Continuing Independence of the Sovereign Native American Indian Nations. That was in June 1974. A couple of years ago, year and a half ago, in June of 2024, we had our 50th anniversary. So it was very good. It was there was a lot of people there. Of course, many of our people have went on to the spirit world. And I'm trying to be fast here, but I'm also trying to give you a background of what was going on. I know many things were happening in our territories at that time. Many of us, people my age, maybe a little bit older, know that there was a lot of unrest and many of us were born into this way of standing up for our rights. In the course of these human events, we call upon people of the world to support the struggle for our sovereign rights and our treaty rights. Treaties between sovereign nations explicitly entail agreements which represent, quote, the supreme law of the land. And in a southern part of our continent here, well, in the middle part of our continent in the USA, uh, that's exactly what it says in their constitution is the supreme law of the land, binding each party to an inviolate international relationship. And that's what I heard you talking about today, about your treaty. Next. And many years ago, and I talked a little bit about 1974. Well, in 1973, a lot of you heard about Wounded Knee. And many of our people went over there from this part of the country, and I'm sure from your part of the country too. I was not one of them. I was busy doing other things. You know how you are when you're young and kind of restless and maybe selfish. That's what happened to me back then. Two vehicle loads of us were supposed to head down to Wounded Knee, and I didn't make my vehicle I was supposed to be on. So a lot of my friends went down there, including Edwin Burnstick Sr. And from there was a lot of work that was done. And from 1974, the declaration that was passed there was instructions for the young people, us young people, to reach out to the international community, to go to other nations, to go to the United Nations. And that's what we did. And this is called, this particular one was called the UN Working Group on Indigenous Populations. 1982 to 2006 is when they had their last meeting. And if you look at the photo here, on the far left is Vernon Belcourt, who has since passed away. The third one is Thomas Banyaka from the Hopi. He's passed away. And the last one on the right is Philip Deere. I mentioned him before. He's gone to the spirit world too. And at the first meeting in 1982, there was very few of us in that meeting, indigenous peoples from different parts of the world. I'm only guessing, it should be there for the record, but I believe there was no more than 30 of us indigenous peoples, and quite a few from North America. And so when you think about it, since that time, a lot of work has happened. And although the UN is, if you want answers overnight, you're not going to get them. It's sort of a struggle, but nevertheless, a lot of work has been done. There was a study on treaties, lands and resources, free, prior, and informed consent, cultural heritage, and these are all available online. You can Google them. And of course, there's the UN Declaration on the Rights of Indigenous People. And there's an ongoing dialogue out there about the original text, which we were part of. What finally got adopted was not what we agreed to. However, in a spirit of compromise, that's what's out there now. Next, sorry, I don't want to try not to take too much time. I thought it'd be appropriate to include this in there. In 1983, we had a treaty conference in a place called Okima, Oklahoma. And I know you can't really see, it's really dark. The one on the far right, wearing the hat with the feather in there, that's Philip Deere, the late Philip Deere. And this was at his roundhouse. And a lot of people in this photo are no longer alive. On the far right is a man named Alex Redcrow. He's from Satellite Cree Nation, my adopted brother. The lady in between him and I was a chief, and she's no longer with us. And in the middle there is myself. And to my right is Eric Robinson, whom a lot of you know. He's still active. The one and the one on the far left is Bill Means, who is still with us. The one in between Eric and Bill Means is no longer with us. He was chief of Swan Lake in Manitoba, I believe. In the back is a lady from British Columbia, and the two young men in the middle are from Jay Mason is one of them from Ontario. So anyway, I just thought I'd share that with you just to bring it into perspective. We were all young one time, and I have that as my screensaver on my laptop. Next. And this is our friend, our late great friend. Many of you have met him. Many of you have heard of him. His name is Miguel Alfonso Martinez. And he was the one that did the UN study on treaties, agreements, and other constructive arrangements. And when it started, when we drafted the resolution for this, we wanted a study on treaties. But then again, governments were sitting across the table. And again, in the spirit of compromise, we agreed to agreements and other constructive arrangements. So if they're not treaties proper, then they're included in here too. So I'll just read this very quickly. This is a quote from him. In the case of indigenous peoples who concluded treaties or other legal instruments with European settlers and or their continuators in the colonization process, the special rapporteur has not found any sound legal argument to sustain the argument that they have lost their international juridical status as nations or peoples. And this is part of his final conclusions. Next. And again, this was part of our history. I wasn't at this particular meeting in New York, but one of the people I work with was there. And when this vote was happening, she called me, and I answered, and I could hear sort of an uproar in the back. And she said, we got it, it's passed. And that's the UN declaration, the adoption on September 13, 2007. And if you look, I know it's kind of blurry, but if you look, the green ones are the ones that voted positive. The red are the ones that voted negative, and the amber are the ones that didn't vote one way or the other. And it was overwhelmingly passed. And I know you all know by now who the four were that voted against it: Canada, Australia, United States, and New Zealand. So, but they've since changed their position. At least they make it look like it. Next. And again, the declaration is a minimum standard. It's the floor, not the ceiling. And this speaks for itself, so I won't read it. Well, I will read it. I think it's important. The rights recognized herein constitute the minimum standards for the survival, dignity, and well-being of the indigenous peoples of the world. That's Article 43. And very important for the little ones that are in that picture. They're probably all grown up now and probably have children too. So next. Inherent rights, and this is part of the preamble, recognizing the urgent need to respect and promote the inherent rights of indigenous peoples, which derive from their political, economic, and social structures, and from their cultures, spiritual traditions, histories, and philosophies, especially their rights to their lands, territories, and resources. And folks, I'm sorry I don't have a lot of time that I would take, but I didn't mean to skip over in 1980, and it's not in here, but there was a UN conference on indigenous peoples in the land, and many of us attended that meeting, including late Billy Diamond, and regarding the James Bay Cree Northern Quebec Agreement, and he was there, and I remember him very well, and how he was really promoting your rights at that level. Matter of fact, there was a big article on Maclean's magazine, and he must have bought about 100 of them, and he was passing them out, and that was pretty cool to see that. Next, Article 3, and this is one that we had a real struggle. There was a lot of back and forth dialogue on this until we reached the language that's there now. And for your information, I was involved in every step of this process. And way back then, I was a really young person, and I remember the first meeting in Geneva. Met quite a few people there that time, and many of them are no longer with us, and really think about them, and pretty hard to follow and fill their footprints. Indigenous peoples have the right of self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development. And of course, this language is already in the different charters and declarations in the UN. The only thing is we wanted to reaffirm it by saying indigenous peoples so that we could be included, because the deliberation of all the other instruments we are not part of, because we all know that it's a good old boys club, all the European powers and the different countries that were created. The UN is theirs. And this was a reminder to them that we as indigenous peoples exist worldwide, all over this globe. Next. Another one we had a very long discussion about, because Canada was across the table, the other countries, and they dragged their feet all the way. But we also stood our ground, and it's self-explanatory. Indigenous peoples have the right to the lands, territories, and resources which they have traditionally owned, occupied, or otherwise used or acquired. And this is not, they can if they want to, or whatever. It says states shall give legal recognition and protection to these lands, territories, and resources. Such recognition shall be conducted with due respect to the customs, traditions, and land tenure systems of the indigenous peoples concerned. And I just want to remind everybody that these articles are all there for us, and they have not been respected. Like what it says here, it's not happening in Canada. Although we remind them and we tell them, legally, this is what you're obligated to do. But it's going to take us some time. But I think what keeps us going is our elders, our ceremonies, and our traditions. And I think we need to carry on in that manner. Next. The international standing of treaties, and this is what you're meeting about, and it's very, very important. I heard a little bit the discussion about the annuity payments and all that, and I have my own point of view on that, but I'll keep it to myself. You had a very good discussion on that. Number one, Indigenous peoples have the right to the recognition, observance, and enforcement of treaties, agreements, and other constructive arrangements concluded with states or their successors, and to have states honor and respect such treaties, agreements, and other constructive arrangements. Nothing in this declaration may be interpreted as diminishing or eliminating the rights of Indigenous peoples contained in treaties, agreements, and other constructive arrangements. And this is Article 37. And I'll talk a little bit about it just a little bit later. We're also involved in the OAS Declaration, which is the Hemispheric Declaration here, Organization of American States. Next. And this one too, free, prior, and informed consent. Very, very misconstrued by governments, like the boogeyman, they're saying, well, we can't give Native people, Indigenous people a veto. This is a veto, but it's not. It's very self-explanatory, free, prior, and informed consent. So it means if they have an idea of a project, before anything happens, paperwork, anything, they need to sit down with us. They need to ask us, this is what we want to do. Do you think it's a good idea? How is it going to affect your stand? How is it going to affect your land, your use, all of that? Not like the way it's been happening where the document's already said and done, and they're using some of our own people to come to our band offices and do a dog and pony show, try to convince us how good this is for us. There's so many jobs and, there's spin-off opportunities, but they never tell us how much water they need. They never tell us the real impact it's going to have on the habitat of the wild game that we still depend upon. And this is all it's saying. And there's not supposed to be any coercion. A few people shouldn't be paid off so they could say yes or try to convince you to say yes. We're looking at multi-generational, I guess, effects that it could have on our Chapans. In my language, in the Cree language, Chapan is a great grandchild, and all the others great, etc. Next. Consent. Consent is a treaty right. And this is from Treaty number 6. And I included in here just to show you an example. And whereas the said Indians have been notified and informed by Her Majesty's said commissioners that it is the desire of Her Majesty to open up for settlement, immigration, and such other purposes as to Her Majesty may seem meet, a tract of land bounded and described as hereinafter mentioned, to obtain the consent thereto of her Indian subjects inhabiting the said tract, to make a treaty and arrange with them so that there may be peace and goodwill between them and Her Majesty, and that they may know and be assured of what allowance they are to count upon and receive from Her Majesty's bounty and benevolence. And, very pretty language, but when you think about it, whose bounty and benevolence is really being talked about? That didn't belong to Her Majesty and still doesn't. It was the bounty and benevolence of our territories, and it was our ancestors that allowed to take these people in because they were fleeing persecution, feudalism, and many of them got here to our territory with just the clothes on their back. They had nothing. They were poor, and our ancestors took them in. That's how kind-hearted our ancestors were. And you fast forward to today, or they were also fleeing taxation. And now you fast forward to today, and they are now trying to do to us what they were fleeing from in Europe. Isn't that it's just hard to believe for me when I think about it. Such a big country, so little people compared to the rest of the world, and yet they want to own everything that we have, the little bits of land that we have. Nothing but pure greed. Next. And this, I talked about this a little bit, the American Declaration. We're involved in there, and you can read it for yourself. I'll just talk a little bit about it. When we were over there, and some of you that have been to the UN, you know that this is true. A lot of the decisions and lobbying that takes place doesn't happen within the hall of the meeting hall with the United Nations. It happens out in the hallways, in the coffee shops, and places like that. So during this UN OAS declaration, during the deliberations, we were on break. So I went downstairs. This at the OAS building in Washington D.C. Went downstairs to use the facility, and I was in there, and just over to my right there, I heard this. I heard a familiar voice, Wilton Littlechild. Many of you know him. He asked a question. He said, "So did you phone the Capitol?" And another voice answered, said, "Yes, I did." So what happened? Yeah, they said we can agree with this. So, just to show you that the strange places that some of these decisions are made, and the delegates there do what the Capitol tells them, and in this case, to agree with this language here that's before you. So, next, sorry, I know I'm taking too long. And again, this is self-explanatory, and in other versions, I include some of our people on this side that stand up for the land, and but this is an example at Mount Rushmore, when people stand up to defend the rights to land and all of that, free, prior, and informed consent, they get criminalized. And I know that there's steps happening to try to deal with that issue. So just an example. Next. And this is one of our friends that many of you will know. He was the former Special Rapporteur on the Rights of Indigenous Peoples. Many of them, good friends, know him as Pancho, Francisco Cali Say. And he used to be on our board of directors of the International Indian Treaty Council. He was our president. And when he was asked to be the Special Rapporteur on the Rights of Indigenous Peoples, my other fellow board members had a discussion that I wasn't aware of, and they decided to ask me to take his place and to be the president of the International Indian Treaty Council. I didn't ask for it, but my elders, Kihtiyak, they told me a long time ago when I was young, if somebody calls upon you to do something to help, do the best you can. That's all you can do. Don't refuse. So that's what happened. It was back in 2020. So I've been in that position now for 6 years. Don't know how much longer I can do it. I also am having some health challenges. But so this is just to let you know. I'll read the last part. We call on authorities to initiate dialogue with the Great Sioux Nation for the resolution of treaty violations. And again, I said this is just one version. There's another version that talks about other treaties. So, and it's just an example. Next. And this is CERD. And quite a few years back, I was very proud of our people. A lot of them actually went to the CERD in Geneva, Switzerland. They went there with their headdresses, their regalia, and they sat within that committee. Now, how that committee works is you can't ask questions directly of the countries that are being reviewed, but you can do it through the committee members, and that's what our leaders did. That time, Canada was being reviewed, and so I think that process is very important. There's urgent action, early warning, and without really getting into it too deep, uh, way back then, I believe it was 2012, when a bunch of our leaders were there. They asked the chairperson from Ireland, I believe she was, to ask Canada to produce a piece of paper that says that they own this land, like a bill of sale that say that the indigenous people, whether they be Cree or Anishinaabe, whatever, uh, gave them title to this land. And how many years is that now? 14 years. They still haven't been able to produce that piece of paper, and they're never going to because it doesn't exist. And but there's a process in place right now where they're trying to do that through the First Nations Land Management Agreement, the financial agreements. There's a whole thread of legislations that are really trying to do this, and they never sleep. They never stop. They have a room full of lawyers where, we're still poor people. We can't afford to hire many lawyers, and so they're trying to win the battle that way. But we have prayer, we have our elders, we have our ceremonies, which we can never let go of. So wanted to encourage you. I know you have ceremonies too, so please continue on, Kihtea. We need you. We need your prayers. Next. And again, this is the expert mechanism on the rights of Indigenous peoples. So people can still go to Geneva. This is where MRIP holds a meeting every summer. And I won't read this, but you can read it for yourself. And this presentation that I have, it's available to you. You can ask the organizers there to print out a copy, and they can give you a copy, or an electronic copy. We like people to spread the message and of the work that's going on. And it's not only us that are doing this work. Many people are also continuing to do this kind of work nationally, internationally, globally. One thing that hasn't happened yet is that we continue to call for the fourth UN treaty seminar. 3 happened, but the fourth one still needs to happen. So you can read it, and it would be good for you to support too, that we could have a fourth UN treaty seminar in someplace reasonable. Right now, the US is not reasonable. A lot of poor people, indigenous people, cannot get into the US. It's because of the political situation, and I'll leave it at that. Next. I've taken too long already, I know that. MRIP's advice to the Human Rights Council in September 2022 states should establish appropriate arbitrary mechanisms in partnership with the indigenous peoples to address claims about violations of agreements, resolve disputes, and redress and remedy grievances. These mechanisms should be independent and impartial, and their decisions should be binding and enforceable. Indigenous approaches to dispute resolution and Indigenous laws should be included in the methods of conflict resolution. Conflict resolution mechanisms must be guided by international human rights law, including the rights of Indigenous peoples. So it speaks for itself. It's saying a lot just in that one paragraph. So next. And again, there was a study that MRIP did on sort of a follow-up on a treaty study, and this is a picture of an old treaty council down in lower 48. Next. And again, this one is pretty important. I invited our good friend Pancho to come to Edmonton. We're having a youth conference, and this was an official UN visit. You can invite these rapporteurs. You can even pay for their airfare. They can come to your territory. But unless it's an official UN visit, then a report won't come out of that. It won't. He might do a report, but it won't be sanctioned by the UN. So there's a process on how to do that, and I think it's important. And this is just one of the statements that he made. The relationship of Indigenous peoples with their lands and territories has a central role in defining their identity as distinct peoples. I repeatedly heard during the course of my visit that true reconciliation can only be achieved by respecting existing treaties and providing restitution and compensation for the loss of lands, territories, and resources. And when he came to this treaty conference or youth conference about 3 years ago, I was his chauffeur. I drove him all over the place. Even drove him to a sweat lodge ceremony and also a feast. So he really enjoyed himself. He was one of them. Now today he's the Guatemalan ambassador to Geneva, Switzerland. So he's still very active. Next. Good. All right. Sorry, friends and relatives. Sorry I took so long. There's so much more I could mention, but I'll leave it at that. I know you have a long agenda, and it's getting towards the end of the day where you are. And I just want to thank you for this time. And I want to thank Andrew in particular for asking me to make this presentation. And once again, I hope I can come to your territory at some point in the future. I won't do such a haphazard presentation that time, and I could be I could be there for questions and answers. So thank you very much.
Thank you very much. And I'm sure there are maybe a couple of people that have any kind of question. Anybody? Ronnie, you still there?
I'm still here, yeah.
Okay, maybe get a couple of questions if somebody has them. Go ahead, Don.
It's nothing really. I just want to see if we can see him.
Oh, sorry, my camera is on. I'm not sure what's going on, but yeah, I'm not the best technical person either. I'm like some of the people that are there. I just turned 73 a couple of days ago, March 2nd. So I'm still a young elder, I think. My apologies. I do have my camera on, but I don't know what's happening. I'm not trying to hide from you or anything, but
Thank you for the presentation. I really enjoyed that. I wish it could be longer. I like learning about that history, and the UN is something. It's a whole different world. It seems in the UN. But I'm still learning about it. But one of the questions that I've been like pondering on is what effective changes can actually can come out of the UN, since it doesn't have like the ability to like enforce countries to follow like the regulations or whatever it is that they put out. And especially with like the lack of social order within the world that we're seeing today, is for myself, I see the UN as sort of, I don't have the word, but like a shaming tactic in a way to place pressure on different countries. But without that social order, like what are some ways to go around it to create changes and like, yeah, just actionable changes for Indigenous people in like Canada, for example? I don't know.
Thank you. That's a very good question, and I wish I could answer it. However, there are some processes, and like you said, I did go through the presentation in a bit of a haste. But like for example, the CERD, there are treaties that Canada has entered into with the international community, and they're bound by these treaties. And the UN CERD is one of them. And many of you probably know Sharon Venn. She does a lot of work in this area. And many of us have drafted urgent action, early warning procedures when the government of Canada was trying to shove many of these legislations down our throats. Many initiatives like pharmacare and all of these other things. There are things that we can attempt to do, and you're right. It is, but it works a little bit better for us because Canada sort of purports to be a champion on human rights internationally. And when they're reminded, hey, what's happening in your own backyard? Look at, you have poor people, one of the richest countries in the world, and we still have people that are poor and struggle with very little income, and with the price of everything skyrocketing. And you're right, international community, the different countries, they use any excuse to dig further into our pockets and to make themselves richer, the upper 2%. And that's happening even right now with this so-called war in the Middle East. The price of everything is skyrocketing. So I think we really have to continue this work that we're doing. It's not something that's going to happen overnight. But now today with the young people and the social media that's out there, it's not like when we were young. You know, you didn't know that something was happening in Peru, you know, for a day or two. Today it's instantaneous. It's like right now. And I think in that way we can support one another. We can get the message out there. And, you know, I guess I can be called a bit of a dinosaur because I'm not on Facebook and these kind of things. But I see a lot of my talks and my presentations that are on YouTube. And so, and I've been involved in a lot of these processes, and I'm to the point now where I have grandchildren, I have great grandchildren now too. So I want to make sure that there's something there for them. And I also want to be a good ancestor like our ancestors were, what they put in place for us. I want to be able to, I don't want my grandchildren to say, well, Grandpa, why didn't you do this? What did you do? I want to be able to show them that we did what we could. But one thing that's important, and I know you're a young person, I hope you're involved in your ceremonies. I hope you know your language. That's very, very important. I think we need to continue to do that, uh, to attend the ceremonies, to be part of it, to help out the elders that need help, to maintain our ways. And that's what I try to pass on to my children, my grandchildren, and my great grandchildren. So I know it doesn't exactly answer your question, but to put it very bluntly, yes, it is an old boys club. That's what it is. The UN that's what it is. And I know many young people are saying, well, if the UN is so effective, how come Russia invaded Ukraine? How come Donald Trump is invading Iran? Yeah, I agree with you. But, when you really think about it, they can't blame just Trump, because they're the ones who put him in there. I just can't understand the American people. Why would they put a person like him in power unless he's saying things that they think and they're afraid to say for themselves? But he's very unapologetic, redneck, total racist through and through. And sad truth is that's what he is. Sorry, I'm rambled on too long.
Okay, thank you very much. I got one more question.
Okay.
Alvin Beardy?
Good afternoon, everyone. I'm trying to, I was wondering about when the states opposed the UN declaration. At one point, they were so opposed to the OTS on the indigenous peoples, or it says indigenous peoples. What was their intent, trying to eliminate the DS of the from the peoples? I'm wanting to find out because when I was working with Sharon Venn, we had quite a battle with the states in Geneva, and I'm still and I was puzzled by that. I mean, the things that we explained it, how we saw ourselves as First Nations peoples or Indigenous peoples, however you want to say it. It's a collective, and for community of each First Nation. So I just wanted to know why were they trying to get rid of the ester from the declaration? Maybe you can put some clarification on it.
Yes, thank you for the question and bringing that up. Wow, that was such a long battle we had over one letter, just the letter S. And they fought tooth and nail. But the difference is the term peoples is an internationally recognized term. So that means although, they're not giving us anything, but the term peoples, we are Nihio peoples. Like, I'm not exactly sure in your part of the country how you say who you are. In my part of the country over here in the Plains Cree dialect, we say Nihioak, Nihio peoples. We were peoples always in terms of the international recognition of the term peoples. And it was quite a battle and was very, very interesting. And even today, it seemed like government officials are trained never to use the term indigenous peoples. Whenever they correspond with you, you notice that they say the Anishinaabe people, of NAN or the Cree people of NAN. They never use that term peoples because of the international implications of the term peoples. But thank you. It's good that you brought that up. It shouldn't be that way. We all know that. But that's the kind of people that we're dealing with when we're sitting across the table. And you know what? They were there when we were elaborating the UN declaration. They were sitting across the table from us, and they said that they reserved their judgment. And next time you see Sharon, ask her. Matter of fact, ironically, Sharon is just in the other room from where I am here today. But one of the things a few of us went for coffee during these elaborations, and this group that was across the divider on the other side didn't know that we were there. We just got there. And we heard them talking, and they were laughing. They were saying, oh, yeah, they can bring out whatever they want. They can, demand this and that. But once it leaves this place, now it's going to be in our court. We're going to make whatever changes that we want. So what we did that time is we drafted a resolution demanding that we be involved every step of the way where the declaration was being elaborated, including the higher bodies where it went to. And that resolution passed. So it just so happened that we were able to be involved, except for the General Assembly, because we don't have a seat there, we don't have a vote. And that's where they made the change where they included territorial integrity. So just to let you know that. But thank you, and my apologies. I'm going to have to go. People are waiting for me here. So thank you for allowing me to be a small part of your meeting. Go ahead and make copies for yourselves, or take USB copies and read the presentation at your leisure. And thank you so much. Hi.
Okay, thank you so much for the word. Ron Lehman. Okay, now I'm gonna move on to the agenda, switch it around a little bit. To the almost 5 o'clock. Gonna ask Mike Sherry to do the last presentation for today.
Okay, thanks, Ben. Can you hear me? Yeah, I'm right here. So yeah, thanks very much for the invitation. It's a privilege to be here. I'd like to acknowledge the knowledge keepers, elders, deputy grand chiefs, and my NAN friends who are there. Sorry I can't be there in person. I was geared up to go Monday morning, but a family matter intervened. So sorry about that. So my topic is Bill 5 and Bill C5 in relation to treaty. And there's written notes, so I won't try not to read it word for word, and I'll also be available tomorrow for if there's any follow-up or questions. So Bill 5, that's the provincial one, and I know people are generally familiar with this because it was a hot topic last year and continues to be a hot topic. So Bill 5 was introduced by Ontario in April 2025, passed into law in June, and Canada was even speedier. They introduced it in June and passed it in June, although there were discussions beforehand about the general concepts. So even though the bills had potentially very negative effects on First Nations, in spite of objections, the bills were rushed through. The consultation and accommodation process was required by the reconciliation was largely ignored, except on just a pro forma basis. And certainly there was no effort whatsoever to achieve a FIPIC standard. So that's page 1. And page 2, paragraph 3, as Amy Westland mentioned earlier, I think there's the Mikisew case, which holds in general terms that because of parliamentary sovereignty, that the federal and provincial legislative branches don't necessarily have to follow the duty to consult when they're passing legislation. Uh, Although there is that window that Amy talked about, and as well, I would mention that if in a situation like this where the duty to consult and accommodate and maybe even seek consent have been ignored, that does create a significant risk factor for the legislation because it can be a matter of constitutional challenge later on. So both these bills are, to me, at risk from a constitutional point of view because they were rushed through, for no good reason in retrospect. The two bills, I think it's important to look at them as a coordinated effort by Ontario and Canada. They're meant to complement each other, although there are some differences in approach, which we'll talk about. So the provincial government under Ford and the federal government under Carney, in general terms, they shared a worldview about favoring large-scale capital development, particularly in the resource sector, energy and mining in particular. They supported borrowing and other measures to foster that kind of development, in contrast to disfavoring soft things. They would probably term them as soft, like non-capital development programs and services. So that worldview, which is sometimes been characterized as very much a 19th century focus, is where they were coming from, as opposed to more of a modern emphasis on, of course, resources, but also technology, information, communications, and that kind of thing. So that shared worldview of Ontario and Canada is reflected in Bills 5 and C5, and also in more recent budget policy. Starting in January of 2025, the Trump government in the US introduced radical tariffs and other measures that disrupted trade. The Trump government seemed to have a particular set of grievances against Canada, even to the point of suggesting that Canada should join the US as a 51st state. So whether that was serious or not, we don't know. So this caused an atmosphere of political crisis in Canada last year. So this was the period of, as people remember, elbows up, which is now part of the language. So, however, from today's perspective, in March of 2026, the pressure has relented somewhat for various reasons, including actions taken by the federal government in terms of trade, and also in terms of the U.S. Supreme Court undercutting a lot of the president's power to impose tariffs on a discretionary basis. However, it's important to recall that just over a year ago, that there really was, the common wisdom was that there was a crisis and that extreme measures were required. But that atmosphere is breaking up now. Next page, starting with paragraph 7. So the dark arts of government include the idea that when there's a crisis, you should take advantage of it, not waste the opportunity. And I think, in my view, that's what Ontario and Canada did in terms of the Trump trade crisis. That although it was an extremely negative environment, there was an opportunity to push through radical economic development measures that would not have been possible in more normal political times. In particular, the governments felt empowered to brush past First Nations rights and interests in terms of these two bills. So the result was the two bills, they were consistent with their worldview of capital-intensive resource and energy development. These were things that the governments wanted to do anyway, but they grabbed the opportunity presented by Trump to rush things along. Even with the accelerated mechanisms of Bill 5 and Bill C5, the reality is that significant projects, especially mining projects, take many years to reach the operational stage. So the reality is that even with the bills in place, that the mines that are being talked about now and energy projects and that kind of thing, at least in Ontario, will not be operational. That Trump will be gone, hopefully, but these projects will only be coming online many years from now. So the idea of these rushing through these resource development projects was always not logical and not responsive to the perceived crisis in 2025. And I think Canada and Ontario were aware of that, but they decided to take advantage of the opportunity in any event. And just make a quick historical analogy to World War II, where they were in that context back in the 40s, that the federal government in particular used that crisis to organize certain surrenders of mineral rights on many First Nations, including reserves in NAN territory, and also some expropriations. These were not necessary for the war effort, but again, the federal government took advantage of that opportunity. So there's some analogy to what's happening or what happened last year. So just focus quickly on Ontario, the Bill 5. It's an umbrella piece of legislation that includes amendments to 6 or 7 pieces of legislation, including the Endangered Species Act, and all those. So page 4, all those legislative changes are designed to, by and large, to speed up development, cut through red tape. That's the language they use, and all these changes deserve study and attention because they have real world effects. But however, most of the attention has been paid on the Schedule 9 of the bill, Bill 5, which is the Special Economic Zones Act. Special economic zones, that's the key wording that people have been talking a lot about since and today. So what the Bill 5 did was it created this brand new statute, one of the Special Economic Zone Act. So it's short, but it has a lot of impact. It basically gives the executive branch, the cabinet and ministers, the authority to choose or to select 3 basic categories: trusted proponents. Sometimes people refer to those as cronies. And there's also designated projects, and these would occur within the special economic zones. So those are the 3 main categories that the cabinet can designate: trusted proponents, designated projects, and special economic zones. They're all interrelated. And within these zones, if one is designated, the government, the executive branch, which is basically cabinet, they have a broad power or discretion to override any provincial law or municipal law or provincial regulation. So just as an example, in a zone that might be focused on mining, the government could override or modify the Mining Act, the Environmental Assessment Act, and other pieces of legislation. So that kind of thing would have a direct impact on First Nations, because often First Nations in the case of mining projects, there's a reliance on some of these provincial statutes to affect the consultation and accommodation and sometimes consent processes. The statute, as I said, is quite short. It's very general in nature. The government has issued and passed regulation, which is referred to in paragraph 12, and it has a bit more detail, criteria for designations. So in particular, it provides a lot of specifics on what constitutes a trusted component. And in the regulation, there are a few references to consulting with First Nation communities. There are no such references in the actual statute. But in spite of these references, the bottom line is that the government, the cabinet, has a broad discretion to create zones, proponents, and designated projects. The wording in the regulation is fairly general. For example, a zone is deemed to be appropriate if it's economically significant or strategically important to the Ontario economy. So very broad general wording, which actually doesn't even tie in with the Trump crisis from last year. They've broadened it. In terms of First Nation, if a First Nation was dealing with one of these designations under the Bill 5, the regulation is an important thing to look at in terms of trying to influence the process, if that's what the First Nation wants to do, because there are references to consultation. The Ontario, paragraph 13, Ontario has signaled pretty clearly that the Ring of Fire area in NAN is possibly envisioned as a special economic zone. That's not any kind of a secret to anyone. However, interestingly, to date, the no zone there hasn't been one of these zones created at all by the province. and that includes the Ring of Fire, surprisingly enough. There's been recent information that, which people are aware of, that I think that Ontario has reached agreements with some of the First Nations there, in particular in relation to all-weather road construction. And again, in the media, Ontario has indicated that their preference is to work on this kind of a partnership basis, working through agreements. And the Premier indicated that maybe he doesn't even need Bill 5 to achieve results in relation to the Ring of Fire, that if these agreements can be worked out. So that's kind of a surprising development, but that is the latest on the special economic zones and the Ring of Fire. Getting on to, sorry, the next page, paragraph 14. Getting on to the federal one, Bill C5, Building Canada Act. As I said, it dovetails with Bill 5. So the two statutes should be read together. And that also reflects the political situation, where it does seem that the feds and the province are working together on these things behind the scenes. Unlike the provincial statute, Bill C5 does contain several references to engagement with First Nations. So it's more positive from that point of view. And the key concept here is not special economic zones, but the federal government, meaning the executive branch, the cabinet, can designate national interest projects. That's the key phrase. And they would be listed in a schedule. There is a very broad definition of what constitutes a national interest project. In the case of a designated national interest project, there is an assumption that the project will go ahead. So that is a clash with the principle of FIPIC. And also the federal policy is to try to get approvals within a 2-year period. When a project is designated as a national interest project, the government has a power to override or modify certain federal statutes. So this is similar to the provincial model, but it's more narrow because there's a defined list of federal statutes that can be modified, and they're in the Act. So examples are the Fisheries Act, the Impact Assessment Act. Originally, the Indian Act was in there, which is surprising, but they deleted that. So generally, the approach of the federal bill is more restrained, more somewhat more positive than the Ontario bill, but that's relatively speaking. For example, because based on the references to First Nation engagement, there are certain steps that the federal government has to follow before their project is designated. So if there is an impact on First Nations, there has to be First Nations engagement. And before issuing the authorities to a proponent, again, there has to be consultation with the affected First Nations. So there are steps that have to be followed under the Bill C5 that are clearly laid out, and so that's better than the provincial model, relatively speaking. Canada has, in contrast to Ontario, Canada has used some of its powers under its legislation, Bill C5. There's been I think 8 or 9 projects that have been designated across Canada. The only one that I'm aware of that is within the NAN territory is the Canada Nichols Crawford project, which is near Timmins. And my understanding is that project was well advanced, and so it's yeah, basically a nickel project. And it like a lot of these things that are being done pursuant to both pieces of legislation, it's not really cutting edge critical minerals or anything like that. It's more of the usual kind of mineral products that are out there, copper, nickel, and so forth. Canada has yet to exercise its power in relation to the Ring of Fire. So in that way, there's again suggests coordination between Ontario and Canada. That even though there's been a lot of talk about the Ring of Fire, Canada has not designated as a project, and as I said, Ontario has not used its designated as a special economic zone. Paragraph 18 at the bottom of page 5. This is just going over the Amy Westland talked about she went through the court applications, and one of them is a challenge to Bill 5 and C5 on very general terms. It's based on the right to self-determination, Charter of Rights, also the UNDRIP, and but not so much on treaty rights as Amy laid out. And it's important to recall that this is very general. It attacks the bill in very general terms, so it's not specific to a particular project that might be considered. Sort of building on the previous presentation in relation to UNDRIP in particular, this is on page 6. It's important to note the inconsistency between the two bills. And UNDRIP, paragraph 32, which the previous speaker talked about, requires at least an effort to achieve FIPIC for projects that would affect First Nation lands and resources. There's also Article 37 of UNDRIP, which talks about respecting treaties and other instruments like treaties. In Canada, there's a federal statute which passed in 2021, the UNDRIP Act, which basically endorses UNDRIP. And the Supreme Court of Canada, in a case that's referred to in paragraph 19, decided that UNDRIP, two things, that UNDRIP is now part of Canadian domestic law. That's quite significant. And court also said that the UNDRIP is a framework for implementation of the constitutional principle of reconciliation. So UNDRIP is a very important thing to rely on in terms of future clashes or negotiations involving the two bills. In addition to the court case that Amy went through in more detail, it'll be interesting to see if other parties, perhaps third parties, question bills 5 and C5 on more general constitutional grounds. The grant of authority to the cabinet and the executive branch to override legislation, like in Ontario's case, all legislation without seeking parliamentary approval, is really quite extraordinary and unprecedented. And in the Bill 5 and C5 court case, they refer to the power as the King Henry VIII clause or power. So, and that's particularly true in the case of Ontario, where there's no exceptions to the override power. So there's a serious constitutional argument that there's been an unconstitutional delegation of legislative authority from the legislative branch to the executive branch, which would be a breach of parliamentary sovereignty. And there's a couple of court references there I have to support that, including Mikisew. So just a couple more pages. Page 7, as going back to the first part of the presentation, in the political crisis atmosphere of 2025, there was a sense that the courts might be reluctant to question the exercise of government discretion in this area, in spite of the radical nature of Bills 5 and C5. Amy, I think, touched on this a little bit. And I think is quite accurate, is that last year, if one of these court cases was in front of a court, because of the crisis atmosphere, it would have been difficult for a judge to side with the government. But it's optimistic, I think, that things have cooled down quite a bit, because the factors I mentioned, like the Supreme Court decision in the U.S., and also even Ford, his latest musings on the Ring of Fire. So if that trend continues with, for example, not to get in the weeds of U.S. politics, but depending on the midterm elections this November, that things, hopefully are on an optimistic trend, and that with this cooled down and less of a panic, basically, that I'm optimistic that if these matters reach the courts at some point, that the courts should be take a more balanced approach and not get caught up in the crisis atmosphere. On a related note, just very quickly, paragraph 22 for your reference. This really gets into the weeds a little bit, but there's another bill, C15, a Budget Implementation Act by the federal government, and buried in there is a general power of the federal government to override almost all federal legislation except for the Criminal Code and some other statutes. There's no exemption for the Indian Act. So at a very technical level, that particular measure has to be taken into account here in terms of the federal power to override legislation. So overall, my view, which is pretty a common view, is that the two bills are obviously a significant threat to First Nation rights and interests. However, it's important to remember that Treaty 5 and Treaty 9 rights are protected by Section 35 of the Constitution Act. These are constitutionally protected rights, and these have been interpreted by the Supreme Court to include deep consultation and accommodation when appropriate, and even consent. I take Amy's comments about the veto and all of that, but there are some indications that in the most extreme situations that actual FIPIC and consent may be the correct standard. So I think that's a building kind of concept, especially with the support of UNDRIP now and that decision that I referred to. So Bills 5 and C5, as concerning as they are, as scary as they are, they're only statutes, and they don't have the power. The province and the feds here do not have the power to override constitutionally protected treaty rights. Those are higher order rights, and Canada and Ontario have a general power to modify their statutes, which they do all the time, but they don't have the authority to just breach treaty rights. So that's important to remember that. Yes, they're moving their statutes around like the deck chairs on the Titanic, as they say, but they don't have the veto. They don't have an unilateral power to affect treaty rights. Treaty rights are stronger. So last page. So in more concrete terms, Bills 5 and C5 can huff and puff about special economic zones and national interest projects and the like. But Treaty 5 and 9 rights are secure and unchanged. They're constitutionally binding, and on particular projects and going forward, there remains a constitutional requirement for deep consultation and accommodation, or even consent in some cases, depending on the nature of the project and the effect on treaty rights. So all of that overrides, in my view, Bills 5 and C5. They can't be ignored, of course. That would be foolish, but the fact is that the treaty rights have not been changed by these two bills and their level of constitutional protection. So, and all of this is closely relates to the harvesting clause of the two treaties and the taken up language, which has been referred to, which we can maybe get into tomorrow if there's time. So, in conclusion, as I noted, the general legal challenge that Amy went through, that's been, I believe, filed, that it's important. But going forward, it's also important to watch for specific exercises of Canada and Ontario under the two bills. So far, the governments have been reluctant to use the authorities. They characterize these last year as absolutely vital and critical to the future welfare of Canada. But the fact is that once they got passed, they have not used them to any significant degree. In the case of treaties 5 and 9, the only exception would be that nickel mine, which was already pretty far down the road. But having said that, if Canada and Ontario do choose to make a move, like setting up a special economic zone or a national interest project in relation to the Ring of Fire or anything else important in NAN, then the full scope of Treaty 5 and 9 rights are there to be asserted, and to oppose the use of those particular statutes. And that'll be a situation where there would be real circumstances to look at, real facts, a real project, and real designations by the provincial and federal governments to look at and challenge in court, as opposed to general concepts. So thanks for your patience. Sorry, I know it's tricky. It's the end of the day. So thanks very much.
Thank you, Mike. We got a little bit of time. I'll entertain two questions. How's that? Anybody got any question? Question. Okay, Boris. Can you get the microphone for Morris, please? So Mike, you're still with us, eh?
Yep.
I nearly fell asleep here. Anyway, is copy going to be provided to presentation?
Yeah, yes, of course, yeah. Yeah, it's not top, it's not secret or anything.
I had one question, a very quick question here. I hear some of this, these two bills that were passed. Um, I know there was a huge protest, and I don't think it resulted to anything. But sounds like that these two bills are designed to defeat, the First Nations, I guess, who normally protest under those things. Is it?
Well, I mean, I think the protests were important because it's put on record in various ways that First Nations were opposed to these two bills. And so it's true that the government more or less ignored the protests and passed the bills. But later on, the fact that there were protests and people put their reasons for that on record, that can be used later on as part of the challenge to the validity of the legislation because of the way that the province and the feds really ignored that input from First Nations. So that was still valuable, although you're right that it was in essence ignored by the two governments. In terms of the effect of the bills, I mean, it's clear what they're about. They're designed to sort of expedite resource development in various ways, and in ways that are again very risky from a constitutional point of view for the feds and the province, because this whole idea of the cabinet being able to just override existing legislation at will is really likely to end up in court at some point. So the whole thing is very risky, but from their point of view. But yeah, the intent is to certainly negative toward First Nations and to speed up development. But as I tried to emphasize at the end, is that I mean that's their position. The fact is that these are only statutes, and the treaty rights in are constitutionally protected, and these statutes do not have the authority to just simply override treaty rights and all the interpretations associated with treaty rights.
Anybody else got a question? Melinda wants to do a spin here or something. Going like this to me. Okay, that's it.
Thank you.
Okay, thanks, Mike. Okay, what else you want?
Making it hard, you guys. We're gonna give away a prize. So if they're not here, they don't get it. So. Go ahead.
Lawrence Jeffers. Jeffries.